Good afternoon, everybody. Good morning, wherever you are. Hope everybody is well. Happy holidays. Happy Hanukkah if you celebrated it. Merry Christmas. Whatever else you might celebrate. Enjoy your family, enjoy the end of the year. So I want to do a quick update today before there's a deposition scheduled this afternoon, Pacific time. And I think it's somebody connected to Alpine, as it turns out. We'll see. But before that, there were some filings recently, a whole bunch of filings yesterday and today, and I wanted to bring you up to speed on those filings because they're relevant. Now, before I go on, Renee is leading a group that is seeking to hire counsel to kind of protect the interests of shareholders, retail shareholders. So if you're interested, please reach out to him. He's making quite an effort. There's others involved in assisting him. So if you're interested in helping gTII shareholders, retail, who are not represented, then contact Renee or that group and go for it. And I'm sure he'll make himself available. If you look on X, I don't know if he's here today, but if you look on X, he will usually appear and you'll see some reference. Sometimes he'll respond to some of my tweets or X's, and you can see it there, but I'm sure you'll be able to find it if you can, and they need everybody's help. So reach out, make your own decision on it, of course. But reach out if you're interested in helping retail shareholders get legal representation and have their interests at least represented in hearings, etc. So I'll leave it at that. Before I go on, what goes OOO? Santa walking backwards. Why does Santa have so many gardens? So he can ho, ho, ho. What do you get when you cross a snowman with a vampire? Frostbite. What do you call a snowman with a six-pack? An abdominal snowman. And last but not least, this is the closest to my heart, of course. What is the nationality of Santa Claus? Of course, he's North Polish. All right, so let's move on. So there's a deposition today I've referenced Renee and his group. Please reach out. Everybody who's here today, thank you for following. Like, subscribe, share, comment, cuss, whatever you want to do. So I want to talk about two things. There were a bunch of filings, one related to a settlement with Kathy Griffin, or a proposed settlement with Kathy Griffin, which I wanted to talk about, and one related to those who did not respond. If you recall, there was a process set up where the receiver challenged a bunch of shares. And then they had an opportunity to contest that challenge. And apparently, as to a number of individuals, I'm trying to think what the largest sum, there's some in the millions, but time has passed. They didn't challenge, so the receiver is now seeking an order from the court declaring that those shares should go back to the company, be canceled, and there's a hearing, I think, in March on it. The total number of shares these are situations where the parties whose shares were challenged did not respond timely. The amount of shares is about 40 million shares. So that's 40 million shares that theoretically will be canceled and will be for the benefit of the shareholders and for the receiver. If you recall, the receiver gets 10% of all shares that are brought back in. So he would get 4 million shares. Now, I think that's excessive, but that's neither here nor there. But in terms of bringing back the shares, I think that's a good job by the receiver's counsel. I don't think the receiver is intimately involved in the legal process per se. So that's good. That's a positive move. If you're a gTII shareholder, that 40 million shares will be canceled. Again, my issue is with the receiver's compensation, and I think that should be challenged, at least the reasonableness of it. And also, and I've communicated this to others, when he can unload shares, it shouldn't be the case that he should be able to unload shares before retail traders. Doesn't make sense to me. It seemed to be an opposite of what we're all entitled, we're trying to do. And by having you guys, by having legal representation, that would be something that your counsel would be able to assert at hearings when it came up. So not telling you what to do, just speaking out loud. So there'll be hearing. I guess these people could show up and argue at the hearing before the order is entered, but I think they're in a poor position if they haven't objected to this point in time. So it's likely that a large number, if not all, these 40 million shares will be canceled. I think it was 40 million out of a total of 180 million approximately that were disputed. I think that were labeled disputed, so that's about 20%, which is a good number, obviously. Let's see, 40 out of it. Yeah, about 20%. 22%, something like that. So that's good progress. There'll be a hearing. I'll let you know when the hearing is. Perhaps there will be other counsel involved at that point in time, and we'll move from there. The second matter that I wanted to talk about was that there has apparently been a settlement reached between gTII and Kathy Griffin. Kathy Griffin was one of the officers directors of gTII. They apparently engaged in, and I think we talked about this in the past, they engaged in a mediation. Eventually, and the way it was described in the moving papers, compared to everybody else, Kathy Griffin was extremely helpful, communicative, and a really good resource. And in part, that's how they justify the settlement terms. And I don't know personally, but I'll have to just leave it to them that that's kind of what went on, that she was helpful. And there was a magistrate. A magistrate is like a judge, but not a judge for life. And it's usually a federal court. A magistrate would be in a federal court. But apparently a magistrate assisted in the mediation. So prior to the mediation, Griffin had approximately 13.5 million shares, something like that, approximately. And some of them went to her kids, I think like 1 million shares. Some went to like a sister and like that, smaller number, but total about 13.5, close to 14 million shares. So in this agreement, and I also spoke, did a live stream once where I talked about settlement and why you would settle. You'd have to weigh, likelihood of success, the cost of the litigation. And they go through the cost in the motion. I think they estimated that it might be $300,000 to $500,000 to fully litigate this against her. So, and if you had to litigate against the siblings or the others, there would be another cost on top of that, and it would take time. So you have to evaluate settlement in terms of all those equations. And even though it may be unseemly at times, if you're making a decision for the benefit of the financial benefit of shareholders, then you have to consider that, and it's a reasonable interpretation. Now, when I was talking about a settlement with Reichman, and I don't see any settlement with Reichman, so I don't know what's going on with that. But when I was discussing it, despite the fact that I'd have to hold my nose, I thought, a 10% of the shares or something like that return that he'd be able to retain in litigation. If you get rid of all the other issues and you get all the shares back, I thought 10% would be a fair number. So in this case, we're looking at 20%, but Ms. Griffin apparently is providing essential information that the receiver, and again, I have no way of knowing if this is true and accurate, or if it's just a way of justifying the motion, but I'm going to presume for the sake of discussion that it's true and accurate. So the agreement basically is that Griffin's going to return 11,142,486 shares. And she'll be able to retain 2,253,000 shares, and her family members will be able to retain about 746,000 shares, which is approximately, no, it's not even approximately, that's 3 million total shares. So the total number would be, she and her family started off with 14,142,486 shares, and they'll end up with 3 million. So they're giving back about little less than 20%, it appears. So is that on the high side? In my opinion, that's on the high side. However, if she has really been helpful in nailing others, then I understand why you'd pay a premium for that kind of information. And I know it is confusing and difficult to decide what's reasonable under the circumstances. But in the end, if she in fact is providing information to go after Reichman and others, then I have no problem with that. What I do have an issue with is the lockup period. So she gets 2,200,000 and change. The family members get 750,000 and change, plus or minus. They have a 1-year lockup period, so they can't sell or vote those shares for 1 year. But the lockup period starts August 19th, 2020. No, the lockup period ends August 19th, 2026, which means it started August 19th, 2025. Now we are in, I think it's December 23rd. There hasn't even been a hearing on this yet. So why their lockup period should start from August 19th, so they would be able to sell theoretically before even the stock is tradable, I have a problem with that. Now, there may be some reason there that's needed, but that does not seem fair and equitable to shareholders who can't trade the stock. Why should these guys be able to dump their stock and allegedly disputed shares when normal shareholders cannot? So that's my problem. I don't think that the lockup period should start until the stock is tradable, and the lockup period should be 1 year from that date. Now, Griffin has, again, a little over 2.2 million shares. Her lockup period runs 2 years. But again, it doesn't really run 2 years because it starts August 19th of 2025. Again, I don't think the lockup period when they can't dispose of the shares or vote should start until the stock is tradable. And then it should be 2 years from that date. And that's obviously something that new counsel, if Renee is successful, if new counsel wants to speak up, that would be something they could talk about. I think that's a reasonable objection to that, the lockup, that it should reflect when the stock's tradable, so that people that are accused of misconduct shouldn't get an advantage over normal shareholders. That does not seem to be equitable or reasonable under the circumstances. They do go into a lot of detail how she's helped, etc. And I'll take it on face value that that's why she's entitled to 20% as opposed to like my figure of 10%. But it's still ballpark. So I wouldn't object to the settlement myself. I would object to the lockout portion of the settlement. And, another thing just to throw in, should you be settling without having a final audit? Because are there things in the final audit that might reflect different totals that might change your opinion as to settlement? I don't know what information the Receiver's Counsel has had access to with regard to the final audit, but we haven't seen it. I've asked for a representative of the auditor to be present on January 14th at the 1:30 p.m. kind of status conference, but I don't know if that's going to happen. But I think because it's taken like a year and a half to get an audit, that settling before having a final audit seems to be premature, especially with a large player, unless you have the information and you just can't disclose it. That's a possibility. But it concerned me that the audit has not been produced and they're entering into a settlement involving a significant number of shares, and maybe the numbers are different than what we are being told, or that the receiver knows. Very possible. So those are the two things. One, there's going to be a hearing in March about the 40 million or so shares, the 40 million or so shares, and they'll be hearing, I think it's in February. It's called a motion for a good faith settlement. It means you basically provide the settlement terms to the court, and you ask the court to sanction the settlement, that it's in good faith. And it doesn't have to be, it's not a super high standard, it just has to be reasonable. And again, my only objection here, I could bitch about the shares, but my only objection is the lockup. I don't think that is a fair structure of a lockup. Again, there may be reasons for having done it that way that only counsel for the receiver would know and can't talk about, but I don't know. But it seemed clear in the motion papers, they did indicate that Griffin was providing very meaningful information. So we shall see, because if in fact there's further litigation, I would perceive that kind of information will come out about who helped and where the information came from, etc. So those are the two issues. If counsel's involved, they probably want to be involved on these issues too. After the deposition today of the Alpine associated person, either today or tomorrow, I will do a short live just to kind of update you on what happened. And that's it. So again, there's two quickies. The 40 million that apparently will come back in March, and the 11,142,486 that are subject to a motion to be heard. I think it's in February from Kathy Griffin. So combined, that would be about 51 million shares that would come back. That's about 30% of the total disputed shares. And again, under the agreement that was entered into, that we didn't really have a lot of say in, just to say honest, the receiver gets about 5 million of those shares. We get less dilution, receiver gets 5 million shares. I think the receiver should be restricted in terms of when he can dispose of those shares. I don't think he should be able to dispose of those shares anytime before regular shareholders can. I think it should be that way now. I don't think it's any terms, but I've said it multiple times. And again, any new counsel that comes in can certainly argue that to the court. Anyway, that's all I have to talk about today. Everybody be well, take care. I will advise you after the deposition, either today or tomorrow, and hang in. And that's it. And call Renee.